representative to responsible government. I made a note. Shall I pass it on and have it uploaded?
On what are the non-legislative functions? All right, because that is a question of the court, you can certainly.
Because that's the question.
Yes.
From
Upload.
Can I hand it over?
Yes. Put it as part of Mr. Yeah, can you ask a junior to email it, Dr. Dhawan, to the court master?
We do that. I'm obliged.
Give it to Mr. Prasanna, and he will upload it.
All right, no difficulty.
Along with the access of
All
some of the judges.
All right, thank you, Mr. Jaffer.
But proceeding on the premise that lordships have gone through the
Yes.
submission, there is one apology that I have to make, not but there is one serious error in that written submission. But wherever I have referred to Jammu and Kashmir, please read merger as accession, not merger, because lordship has seen Kashmir did not merge. So that's the error which I have committed. I want to rectify it. Wherever I use the word in my written submission, merger in respect of Jammu and Kashmir, it has to be accession. I'll take just 2 minutes to sum up the context part which the lordships must have seen. Kashmir acceded differently because it acceded post August 47. The rest of the states concluded their accession as well as standstill agreement before August 47. Because standstill agreement was a precondition for instrument of accession. So they had all signed. Kashmir did not do it. And therefore, as per the cabinet mission memorandum 25th May, as well as the India Independence Act 1947, section 6 and 7 and 8, Kashmir acquired independence because the paramountcy ceased on 15th of August 47. That's the crux of the cabinet mission memorandum and the India Independence Act that follows it.
Yes.
The rest of the states barring Kashmir merged through agreements from time to time with the Dominion of India, ceding all their powers and sovereignty, barring Kashmir. And that is what Lordship would notice in the instrument of accession. I would not take Lordships through it, but that is what Lordships notice. All the states unqualified cession of sovereignty to the Dominion of India. Some ceded directly to Dominion of India states, Rajavans. Some ceded the Dominion of India while they merged with the provinces. Provinces, Lordship would know about the provinces under the Government of India Act, and they automatically merged in the Dominion of India. And some ceded to the Federation of States, the Union of States. But eventually, all these ceding rulers and states, Indian states, they accepted that their right to make constitution, which was guaranteed to them in the cabinet mission memorandum, and thereafter under the India Independence Act and the negotiations. They all ceded that Constitution of India will now be the sole constitution, with their constitution merging in the Constitution of India. And that is what is not the genesis of Article 238. Article 238 is significant, and this will answer one of your Lordship's query, that what was the status of Kashmir when it ceded to the Dominion under Article 1 and the schedule.
Where will we get Article 238 actually? Where will we get because our constitution copy doesn't carry it. So if I'll just check.
Not that.
It doesn't have in this, yes. I'll share it with Justice Court. Is it anywhere in the compilations? In the compilations, do we have it somewhere?
I have copies of this, but I brought copies of the.
Anyway,
book.
no, don't worry, we have it here.
You all rely heavily on Mr. Shankar. So very adept at these things.
Will
We are
the
not.
constitution as applicable to the state of J&K have that?
I'm sorry, no?
Will the constitution as applicable to the state of J&K have that? No.
No,
No, 238 is in the Constitution of India.
and
So-
it can't have it because it's barred.
Yeah, that's fine.
No, I'm coming to that. I'm coming to that. There's a slight something to be said. Lordships would bear this in mind that Kashmir ceded and became part of Union of India as Part B state. And all the ruler states were part of Part B state. I mean, they were all Part B in the schedule, first schedule. And therefore, 238 was made applicable to Part B states only, which were Indian states. What 238 does was, it keeps the promise of applying the state's constitution to the government, to the union, the Constitution of India. Part B state, 238 says that Part 6, 7, and consequently Part 11 would also apply to these Part B states. And that is how not all these Indian states merged unconditionally into the Constitution of India. Initially, all the Indian states were promised that they will have their constitution. But then through negotiations, this was taken out. My old vision was it.
Yes.
Now, the status of therefore Kashmir was of a Part B state in the year 1950 when the constitution was enacted. And yet, Lordship would notice in 370, Article 238 was excluded. That speaks volumes about the autonomy of the state.
Yes.
Therefore,
Just hand these up,
Are these given on a returnable basis or on a non-returnable basis?
That's what I got. In fact, when we were arguing Boileau's matter, we were looking for Article 31 and it wasn't in the footnotes. So when we conceived this constitution, we had to put all the old provisions. So
but the only discrimination my friend has is I have been
You want me to have a later edition of this?
it's coming out in 3 days.
But the original, the intention to gift me was not there.
Attorney is very upset that attorney is being discriminated against.
No, you have mine, I have one.
The copy, I can
And-
enter it with my own copy.
Brother has his own copy.
I
So.
have my copy.
No, the attorney should be penal. Now, coming back to the number of this brief, introduction was necessary because the basic theme of ours is that Kashmir was entirely different, and this is what Lordship would notice in the debates.
It's all when it is open to the process.